You were live. Okay, good morning. It is April 25th in Senate Judiciary. We are getting our walkthrough at page 222, and we have ledge counsel with us.
Good morning. So for the record, Michelle Childs, Office of Legislative Counsel, enrolled at page 222 as passed by the House. And so this is dealing with civil orders of protection. So it is amending statutes in your two kind of civil protection order statutes that this committee most often works with, which is the Title 12 provisions regarding orders against stalking or sexual assault, as well as the domestic violence protection orders in Title 15. So section 1, you'll see we're working in Title 12 there. So we're talking about orders against stalking or sexual assault. And we're gonna actually take you to start with looking at page 2 on the existing definition of stalk for purposes of this chapter. And so you'll see the existing definition of stalk, and we didn't make any changes to that other than just like a gender neutral language. But you'll see that the definition of stalk needs to engage purposefully in a course of conduct directed at a specific person that the person engaging the conduct knows or should know would cause a reasonable person to fear for their safety or the safety of a family member, or suffer substantial emotional distress as evidenced by. So I wanted to just draw your attention to that first, because the primary change in this section is the change to the definition of course of conduct. So course of conduct, so for purposes of stalking, you have to show a course of conduct. One particular act does not qualify under the statute. So you see the existing definition of course of conduct means 2 or more acts over a period of time, however short, in which a person follows, monitors, surveils, threatens, or makes threats about another person or interferes with another person's property. And then there's the new language starting in line 11, or use of any electronic, digital, or precise geolocation device or software application to surveil a specific person or a specific person's internet or wireless activity continuously for 12 hours or more, or on 2 or more occasions over a period of time, however short, without authorization. And I think, when you hear from the witnesses, they'll talk to you about why they brought this proposal to the General Assembly around kind of digital stalking issues, right? And so, we've evolved a lot over the last 10 years about the way that you can connect with people, that you can track people, those types of things. And so this new language is to address those particular scenarios.
So, my question about the course of conduct, and maybe this will be clarified later on, but I'm looking at the on lines 13 to 14, 2 or more occasions over a period of time, however short, without authorization. And then I'm looking at surveilling a specific person's internet or wireless activity. In terms of internet or wireless activity, is that referring to what they're doing on the internet, or does it? I guess my question is, if somebody checks or looks at somebody else's Instagram or Facebook profiles on 2 separate occasions, is that surveilling internet activity?
Well, you have to look at it in the context of the definition of stalk.
Okay, right. That was my next question.
Right, so that's why I kind of wanted to start with that, is you have to meet this type of thing, is that, it's the course of conduct that when that person is engaging in the course of conduct, the person knows or should know will cause a reasonable person to fear for the safety or the safety of their family, right? So you have to kind of go back. So there's those elements. So I think if you look at just the definition of course of conduct in itself, right, you could say, oh, well, everybody sometimes kind of, checks out somebody's Facebook page or Instagram page, but you have to take that definition back in and go back to the elements around what's happening. So
just want to make sure there was that connection there. Senator.
Actually, my question is similar, and I'm getting deja vu from this. I know we had a discussion of similar language 2 years ago, 3 years ago, Because my question is, number one, parents surveilling kids, and that's the discussion we had the last time this came up. Now,
So those are not eligible under this order.
okay, why?
Because you are a family member. So if
Okay.
remember the kind of distinction between the Title 12 and the Title 15
No,
orders.
it's not here, so I don't.
So Title 12 orders are
Yeah.
available to people when the plaintiff is filing. The person is not a household or family member.
Okay, so I guess what I'm thinking about is we had a couple of years ago, a similar piece of language that was not in the civil orders for protection, but was in just general statute.
Right. I think I'm trying to remember what bill it was, but I remember this.
Yeah.
Yeah.
Okay, so this is in the context of a civil order for protection. So we're saying this is the conduct that allows the judge to issue the order, right?
Right. So again, orders against stalking or sexual assault, not related to the person.
Yeah.
And they would have to meet for the stalking order, meet this definition of stalk,
Mhm.
Causing the person to fear for their safety or suffer substantial emotional distress, evidenced by a fear of unlawful sexual conduct
Mhm.
or not, so those provisions. And then you would have it course of conduct.
Yeah. To go back to the chair's question, sort of, I was thinking of, I forget what it's called, but my daughter is always checking maps, something, that showed where all of her friends are. And so that's voluntary that they've turned that on so that their friends can see where they are. So she can literally point.
Oh, yeah, mine do it.
Right. I'm wondering, there's so many applications out there that would fall under this. That last phrasing of 2 or more occasions over a period of time, however short, without authorization.
Well, in that certain case,
Yeah.
giving authorization, they share all their information with all their friends or what they do, or they post it on an app. So that's authorized. And again, you have to go back to engaging in conduct knows or should know would cause a reasonable person to fear for their safety.
Yeah. No, I'm just trying to get it clear in my mind. I think I'm fine with it because it's in the context of seeking a civil order for protection as opposed to criminal offense of stalking based on whether somebody surveilled you on the
Right. I mean, I will say that, I guess I just want to clarify is that while the Title 12 orders are for non-household family members, but stalking and the definition of stalk is incorporated into the Title 15 by the definition of abuse. So there's that context. But I think probably, like as you start to think about the scenarios that, because I understand your concern around, kids, teenagers, parents, and watching that, but I think probably some of the criticism about the scenarios there and the conduct that they're trying to reach with this. But I think for me, when I look at this, I look at the definition of stalk. I think I'm comfortable with that it addresses your concerns, that there's not an unintentional kind of issue there.
Senator Morris, that's it.
Yes, I'm on right back in on the same issue here.
Okay.
I see where over a period of time in 1A2, it specifies monitors, surveillance, use of electronic digital continues to 12 hours over a short period of time. However, when it comes to threats or make threats, interferes with the persons. When we say over a period of time or short, but is there a limitation on looking at it from the other end, such as today they did this, and then a year later they did that again? Are we looking at a period of time, looking up on the other end of this?
right, however long.
Yeah.
The statute clearly doesn't address that. I don't know I can check to see whether or not case law has addressed issues where maybe there was like one incident and then a year later there's another incident, and whether or not they've kind of ruled on that issue. I would think that they would be looking at the circumstances as a whole, and so they would be looking at, if there were only two instances, what were those two instances, the duration of time between them, and then going back to the standard, would it cause a reasonable person to fear for their safety, even if there was an extended period of time beyond that? Because that's the question for the judge.
Yeah, I'll just chime in real quick that it's something that's looked at in a lot of different types of cases. Temporal proximity, and it's one of the factors that the court takes on situation when determining intent and also else. That's the most key.
I think I understand how this sort of interplays with the underlying definition of stalking, and I have to be a question for Senator Ishii about how it plays out in practice. My assumption is that simply looking at someone's Facebook page twice in 12 hours is not going to rise to the level of stalking. It has to have additional aspects.
Right. I mean, I would say that that's not a reasonable person.
Right.
Right. If you were on Facebook and you have open access, or even, the people that you have invited to be friends or whatever, first of all, you authorize them to see that information. Right. And I think that I think it would not cause a reasonable person to fear for their safety if someone that you have granted access to your Facebook page takes a look at your Facebook page.
Right. Whereas if someone is tracking where you are through your Facebook page and also making threats and putting that in, like, that sort of rises to a different level.
Correct. I mean, I think a lot of the and again, I think the witnesses can talk more about, give you real world examples of where they're seeing kind of the electronic monitoring.
I can give you a real world example.
Certainly some of the things that have been raised in discussions are, putting an Apple tag, right, on someone and monitoring that without their authorization. Or installing something on their phone, again, without their authorization, that tracks their location and things like that. Yeah, right. Okay, keep going. Okay, so now we're moving on to page 3, section 2. Now we're moving on to Title 15 on domestic violence orders. So this first section 2, this is dealing with the final relief from abuse orders. It's always a little tricky because of the way the statutes were created initially before my time. It's like has the final order, and then afterwards it has the emergency order. So I just want to make sure that we're noting the differences because the language is different in both with regard to possession of a vehicle. So section 2 relates to the final orders, abuse protection order. So remember that there's the ability to file for an emergency ex parte order, and we'll talk about that in the next section 3. But those are only available they can only be for no more than 14 days, and then you have to have a hearing on whether or not to issue a final order. So section 2 is on final orders, and it's just some technical amendments there. But if you look, starting, and you want to start with the intro language on page 4, and subdivision 2, which starts on line 4. And so these are the things that the court can order as part of the abuse protection order, and you'll see the types of things that are there. Subdivision A, refrain from abusing the plaintiff or the plaintiff's children. B, an order that the defendant immediately vacate the household and that the plaintiff be awarded sole possession of a residence. They can order temporary award of parental rights and responsibilities. So thinking about care and custody, where's the child going to be living for that time. D is parent-child contact. That's just a reference on lines 20 and 21 to there's a specific statute with regard to parental rights and responsibilities determinations when there is a history of domestic violence. And that's separate and apart. There's conditions that the court can set in those particular circumstances. And then you have your regular language around how the court determines parental rights and responsibilities of the best interests of the child in 665. So moving on to page 5, again, existing law, child support, subdivision E, and documentation, if they have personal documentation, so if you can't hold on to somebody's passport, addresses the possession of the animals. And then you see down at the bottom of the page, the new subdivision I is an order awarding possession of the vehicle to the plaintiff for a set period of time, provided that going to the top of page 6, is the owner or the joint owner of the vehicle, is the primary payer on the vehicle loan, has primary possession or control over the vehicle, or has been restricted from using the vehicle by the defendant.
Can I ask, I never know this, Michelle, this construction, does it have to be all of them or can it be one of them?
No, it's one of them.
Okay,
So the way that it is, because it's like individual and then there's the or
Yeah.
after the 3 little I's.
okay, so, so all of these things would have to be true for the court to.
No, it's or. It's or, yep.
So one of them.
Yeah, we
Okay.
just don't put like after every one, we don't put or. The way that the list works is if it's, so if we look at the way that it's constructed, and then there's the or applies to all the other ones. We just don't repeat it each time.
And a judge would look into this situation with the vehicle to determine these things, whether they've been restricted or.
Right, and so, and also we'll get to, when we'll look at emergency relief, this issue can be raised at the emergency hearing as well. And so, you know, my guess would be that if the plaintiff is going in and seeking a final order, that they're gonna come with a copy of their loan agreement or, you know, whatever the thing they're gonna have. It's because they're gonna be, you know, presenting their evidence to the court. If they're requesting possession of the vehicle, they're going to come with some evidence there to show that either they're a joint owner or they pay the loan or whatever it is.
So I'm just wondering if a couple has one car, and they're joint owners, or let's say that the order is against the husband, or the attempt to get the order is against the husband. He's the owner of the vehicle, primary payer, has primary possession, but he doesn't let the person take the car because there's only one car. That would still qualify.
Well, it's going to be up to the court to decide. So they're going to be looking at the situation, like there's one car in a family, right? How is that vehicle used, right? So it could be that, you know, it could be that the husband is the owner, pays the loan, and, you know, maybe uses it for work some, but the plaintiff uses it also every day to take the kids to school, right? Or, you know, those types of things. And so they're going to be looking at the whole circumstances there. There's not a requirement, you know, that if the plaintiff files and requests it, it's not a requirement that even if they are the owner, that they all would automatically get the vehicle. They're going to look at the circumstances, you know, and which are going to be really varied.
Yeah, so it's freeing the judge to use more discretion, even though one party may own and pay on it.
Right.
Yeah. Okay.
So, you know, I'm gonna skip J right now and let's go to section 3 because we're talking about vehicles and then I'll come back to J if that's okay. So section 3 is the ex parte emergency order. So as I mentioned, you know, these are the ones where, you know, oftentimes it might happen after regular court hours. The defendant is not there, so they're time limited to 2 weeks. And then you'll see the language on page 7 you'll see starting on line 9, relief under the section shall be limited as follows. And here's the criteria there. So upon a finding that there is an immediate danger of further abuse, right? So that's something the court first has to find to issue the ex parte order, right? So then you have language that is similar, but not necessarily identical to what you have in the final order, which is oftentimes like a higher standard, right? I mean, no, a lower standard, because with the ex parte, you have a higher standard because the defendant is there and able to present their own evidence. So it's things like refraining from abusing the plaintiff, coming with a fixed distance of the plaintiff or the plaintiff's residence or their children. So you see then on page 8 on subdivision 2, upon a finding that the plaintiff or the plaintiff's children or both have been forced from the household and will be without shelter, unless the defendant is ordered to vacate the premises, the court may order, again discretionary, that the defendant vacate immediately the household and may order sole possession of the premises to the plaintiff. So again, so the language is a little different, you know, like between the language that's in the ex parte order and what's in the final order with regard to possession of the residence, because they're having a full hearing for the final order. And so I just kind of wanted to notice that, because then if you look at subdivision 4, the new language around the possession of the vehicle, there's an additional requirement here that's not in the one for the final order, which says that upon a finding that the plaintiff's possession of a vehicle is necessary to escape abuse or prevent further abuse, the court may award possession of the vehicle to the plaintiff for a set period of time. And then it's the same kind of criteria that they would have to offer there. And so, you know, again, because it's an emergency order, the defendant's not there, they may be doing it on a night or weekend. But there has to be this additional finding that the vehicle is necessary to escape the current situation for which that person is petitioning for a protection order.
Yeah.
Okay. So now I'm going to go back to the section I skipped, which was on page 6. So this is back to the final orders, and you'll see on page 6, line 5, subdivision J, something that the court can do, not required to do, but they could issue an order requiring the defendant to complete a domestic violence accountability program approved by the Council on Domestic Violence. So it says failure to complete the program is not considered a crime for any purpose, but may subject the defendant to civil contempt proceedings. So you know that you have 13 VSA 1030, which is a misdemeanor for violation of a protection order. So this is unique, which is that if you violate any of the other provisions of the protection order, you could be subject to charge of the misdemeanor under 1030. But under this circumstance, the policy decision was made in House Judiciary that this is kind of a unique, kind of ongoing condition, and that they didn't want it. They had concerns about failure to, if the person didn't complete the program. I'm not going to recall the details, but it's rather lengthy. There's different types of programs. I'm sure you'll probably hear from the Council on Domestic Violence, and they can talk to you about the various community programs for accountability programs that are out there. So this is a unique one. So if you violate this particular condition, unlike the other conditions, it would be subject potentially to civil contempt proceedings, but not to a violation of the misdemeanor crime in section 1030.
I think it'll be necessary to hear from practitioners on both sides for this, because it is unique. I know DVAP is often used in resolutions for criminal cases where somebody conviction of a first offense of domestic assault, 2 or 4 years of probation, and they have to go through that program. So it is unique that could also now be required in the civil component of it as well, and they may face civil contempt for not completing it. Just know.
Right, and I think, again, once you hear from witnesses, I think some of the testimony in the other body was that they were looking to have those, like right now, you can only access those programs through the criminal side of things, and they wanted to be able to open it up to folks at this stage. So there might not be, so if there's a, as you know, it can either go civil, criminal, or it could have both tracks. But if it's just going civil, perhaps the plaintiff is not interested in pursuing any type of criminal action in the case, but would like their partner to go through this program. My understanding is they don't have access to that program through the civil route now. So successful completion of the program is considered a substantial change in circumstances for purposes of request to modify the order. So if the person goes through and they complete the program, they can go back into court and they drop that condition on the order. A court may consider a defendant's failure to successfully complete the program when determining whether to extend the order. So oftentimes these orders are only in place for a year. Sometimes people will go and ask to extend it beyond that year. Many times they don't, but if they do, then the court can look at, well, did the defendant complete as required under the original order.
Michelle, before we go on to section 4, I'm just keeping an eye on the time. Is 15 minutes enough to go over H28 or S28, the pieces that we may need to look at?
I feel like having Jen here is a good part of that because it's her bill, and I just kind of got pulled in on that. So you guys may have questions about more of the, because some of it is dealing with HIPAA, which I'm no expert on. So let's just, if we can,
Sure.
we'll do this, and then I'll check in with her and see whether are available. We'll meet your needs. We'll figure it out this morning.
That's good. Thanks.
Okay to keep going?
Yes.
All right, so now we're going to look at page 9, section 4, Domestic Violence Fatality Review Commission. So you guys are already familiar with this because you have already discussed H27 around the makeup of the commission and adding near fatality. So there's a new requirement for the commission, which is at the bottom of page 10 in the new subsection H, which is, so they're required to do biennial reports. But their practice has been actually to be doing annual reports, but they're only required to do biennial reports to the General Assembly, Governor, et cetera. And this new requirement in subsection 8 is that in the findings and recommendations, the commission is to report on the number of defendants ordered to complete a domestic violence accountability program approved by the council, and the number of those defendants who completed the program. So again, because this is kind of a new approach, is they wanted the House Judiciary Committee wanted some information back to kind of see how this is working.
Makes sense to me.
Any questions? Thank you.
Sure. I'm just going to step out and see if I can down the chat and see if you sort of
For a second.
Bob?
Said with you opening the question, you want to join us?
Oh, forget
I can hear.
Good morning.
Or floor is yours.
Thank you so much. Carly Glisserman, Policy Director at the Vermont Network Against Domestic and Sexual Violence. Thank you for the opportunity to speak with you today, and for looking at this bill H222 that has some somewhat small but very important changes to the Civil Protection Order statute to provide better relief for survivors. All of these changes came from recommendations from the field. So the Domestic Violence Fatality Review Commission, as well as advocates and attorneys who are working with survivors and going through this process on a week by week, day by day basis. Have really intimate knowledge of what survivors are looking for in the process and also how to protect survivors through the process. So there are three kind of components of H222 that support survivors that I would love to speak to today. So the first piece are the revisions to the civil stalking order definition of course of conduct to better capture device-related stalking. So the definition of stalking in Vermont Civil Protection Order statute requires a course of conduct, so meaning 2 or more acts over a period of time, no matter how short, to meet the threshold for the protection order. So we have heard feedback from service providers that it can be challenging to apply this existing definition of course of conduct in cases of device-related stalking. So as Michelle noted, for example, when a device like an AirTag or a tracking app is placed once and then used to continuously surveil a person, there's been some confusion in the courts of whether those activities meet the threshold of that course of conduct. And so this has left survivors of serious device-related stalking without the protective measures they need. And so the committee noted this kind of question around like monitoring wireless activity. Is that kind of repeatedly checking someone's Facebook? I think as Michelle noted, that key threshold of fear of safety or substantial emotional distress to grant the order is a really important context in which to think about these conditions. So when looking at monitoring wireless activity, we're more thinking about installing apps on people's phones that track their wireless activity, which is an increasingly used tactic for cyber stalking. Another example could potentially be repeatedly contacting someone through social media with threats of sexual violence. That's another kind of example that came up in the House that would potentially meet that definition if it resulted a victim in experiencing fear for their safety or substantial emotional distress. So as technology evolves, we feel that our laws really must evolve with it. And so that is why we propose this language to really close that gap on device-related stalking. Next, looking at the condition of completing a domestic violence accountability program as a form of relief in the domestic violence relief from abuse order statute. So this was a recommendation of the Domestic Violence Fatality Review Commission and their last report. So providing a little bit of background around what domestic violence accountability programs are. So they are community-based treatment programs that are designed to address the needs of people who use violence in intimate partner relationships. DVAPs acknowledge that abusive partners in most cases are capable of change and are seeking to modify their behaviors and develop skills to prevent future. Vermont has 12 DVAPs that offer in-depth community programming. Most participants are court ordered to attend as a condition of a criminal court sentence, as the chair noted. So last year, 85% of participants were referred as a condition of probation by the Department of Corrections, and an additional 11% were referred by DCF as a component of a case plan, and 3% were self-referred. DVAPs are required by statute to be certified by the Vermont Council on Domestic Violence. And so every 2 years, they undergo a rigorous certification process that evaluates their alignment with statewide standards. There's documented policy review and an evaluation by a community review team. So while DVAPs are not the sole vehicle for holding abusive partners accountable and changing behavior, they are a really critical component in the spectrum of our response to domestic violence and can improve outcomes for both survivors and people who use violence. So in the impact of having a DVAP as a condition of a protection order, so survivors can request various forms of relief to keep them and their loved ones safe. It is at the kind of judge's discretion about what is ordered. This is just kind of adding another tool to the toolbox. And it is something that we have heard feedback from survivors consistently that this is an option that they want. Because there are a large number of survivors who pursue civil protection orders and no parallel criminal process. And currently, there's a really significant gap in the referral pathway to DVAP in civil cases. it is very unlikely that a survivor's current or former partner will be referred to DVAP without a criminal process currently, even if it is what the survivor wants. Many survivors report that DVAP programming can change their behavior of a partner and would be extremely helpful as part of a civil protection order statute. Survivors may want to reduce risk of violence for their shared children, future partner, or themselves if they want to maintain the relationship. And so this component would expand options for survivors and the courts and support people who cause harm in accessing services to change their behaviors. And also earlier access to DVAP programming can reduce the risk of violence and stop abusive behavior escalation before it gets to a point that is more harmful for survivors and their families. And lastly, speaking to the piece on temporary possession of a vehicle as a form of relief in a protection order statute. So as Michelle noted, this is again just another option for the court to consider. The protection order statute currently explicitly lists various forms of relief to survivors, including primary possession of a resident's pets or children, but it doesn't currently explicitly list primary possession of a vehicle as a form of relief. And so this is feedback that we heard from our legal clinics that in Vermont, especially rural areas, you know, a car can really be a lifeline for survivors and prevent them from escaping abuse if they do not have access to a vehicle to leave or transport their children to school, maintain their job after they leave a relationship with violence. We feel that it is important to explicitly add primary possession of a vehicle as a car can be a lifeline and support survivors in leading independent lives immediately after leaving an abusive relationship. So I know that was a lot to throw at you all. I would be happy to answer any questions or speak in more detail to any portions of the bill. I really appreciate you taking the time to review it today.
Yeah, thank you for your testimony. I think my question I should have asked Michelle, but the order requiring the defendant to complete DVAP, would that come in a final order or temporary? So it can't happen in the temporary order. Okay,
Yeah.
just want to make sure. Thank you. Committee, any questions?
I just have a question about the car piece. I'm just thinking through on that one a little bit more. Awarding possession of a vehicle for the plaintiff. What is there any thought in the bill about, me and somebody own a car together?
Mhm.
I have the account for OnStar
Mhm.
and the plaintiff is awarded the vehicle.
Mhm.
Is there any thought in the bill about that OnStar part? Because you don't give authorization, but like when I bought my truck, you set up OnStar, cool. And then my wife takes my truck, cool. I'm too cheap to keep paying for it, so I don't have it. But somebody can have OnStar and be able to track it. And if they're one of the owners, there's no authorization there,
Mhm.
but they can still track the individual that now has the car, but is part of this.
You could fall into that.
I think
Yeah.
that would, I think the piece that applies to last year's question was for Charlie as well.
This is such a great question. So there is a bill in the House right now, H223, that is taking a look at connected vehicles and the way that abuse can be facilitated through connected vehicles in situations like the one that you noted. I can share an article and follow up here that details some cases where survivors were being tracked through a vehicle. So they had a shared vehicle, they escaped an abusive relationship using the vehicle, and then their location was being tracked to domestic violence shelters and used to harass them after they left the relationship. And despite contacting repeatedly the car manufacturers to disable that connection, they were told they would not be able to do that. And so in response, California and New York have both passed laws that outline a process that car manufacturers must go through if a survivor of domestic violence requests that their connected vehicle access is severed. That is not part of this bill, but it is a conversation that we are really interested in having. As tracking apps and connected vehicles are increasingly the way that technology facilitated use is happening these days. As far as in this bill, you know, I think it really depends on the circumstances. If it would fall under the conditions to get a civil stalking order. As Michelle noted, stalking orders are really used for people who do not have a relationship, like domestic relationship. But that course of conduct definition that we are amending here is cross-referenced in the domestic violence relief from abuse order statute. So depending on the conditions, there could be relief for the survivor.
Okay, because that'd just be a really big worry for me. No, that's perfect, because you have big worry for me if a judge awarded a vehicle and then it led to the exact, basically authorization of tracking somebody based on that.
Yeah, exactly. I mean, it's something that there is a lot of education in our field now about, you know, what survivors should be looking for when they leave a relationship, potential risk factors. You know, technology, it's moving really quickly. And I am shocked on a weekly basis about the new tools that are available to facilitate abuse. And so that is certainly an education opportunity if this bill continues to move forward.
Thanks.
Thank you.
Anything further? Thank you.
Thank you so much.
Got 131, and I don't know if Jen is gonna be making it in, so need to take a break.